Good afternoon, Your Honor. Assistant Prosecutor Kelly Collins appearing on behalf of the people as well.
And Ms. Lofton.
Yes, good afternoon, Your Honor. Paulette Michelle Lofton on behalf of Mr. Crumbly. Your Honor, we also have Amy Hopp, who has been appointed second chair. And we also have Deborah McKelvey, who has been appointed to act as Mr. Crumbly's guardian ad litem.
Thank you. With that, Ms. Hopp, if you just want to state your full name, and then we'll give Ms. McKelvey a chance to do that as well.
Amy Hopp appearing on behalf of Ethan Crumbly.
Thank you. And Ms. McKelvey.
Good afternoon, Your Honor. Deborah H. McKelvey, court-appointed guardian ad litem on behalf of Ethan Crumbly.
Thank you. And Mr. Crumbly, could you state your full name for us, please?
Ethan Robert Crumbly.
Thank you, Mr. Crumbly. If at any time you cannot hear or understand myself or any of the parties to the proceeding, will you please let the court know?
Yes, ma'am.
And we are proceeding remotely instead of in person at the courthouse. Mr. Keese, is that with your consent?
It is, Judge. Thank you.
And Ms. Lofton.
Yes, Your Honor, I did discuss that with Mr. Crumbly. We are okay today to proceed by Zoom.
Thank you. So as the attorneys have already mentioned, Ms. McKelvey has been appointed by the court this past Friday. The request was made by the defense and was agreed to by the prosecution. And the court finds that it is in the defendant's best interest for that appointment. The guardian ad litem duties and authorities are set forth in a court order that is contained in the court's file. There was also a stipulated order for discovery, or protective order, I should say, that was entered into on Friday. I did just receive another copy with the original signature of yourself, Mr. Keast. It was attached to the front of the file when I walked in. Does that mean you want me to re-sign the order and redate it today's date? Is it just for the court's file?
Judge, that's just for the court's file. Thank you.
Okay, great. Thank you. So, and I do want to thank all the attorneys for working together on this matter. I really appreciate it. That's evidenced by the protective order that I'm sure took some time to agree upon. So I appreciate your continued cooperation with one another in the court to make sure that the interests of justice are served. So thank you again. And I know that discovery is coming in and it's being provided to Ms. Lofton and Ms. Hopp. What's the status of that?
Thank you, Judge. We were able to get approximately 500 pages of reports and witness statements to counsel on Friday after the protective order was agreed to and submitted to this court. We do have a number of items outstanding. As this court can imagine, this was an extremely unique circumstance. There are a number of witness interviews to be commenced. For one reason in particular, Judge, is that a number of these children who were at the school were victimized and traumatized themselves. That naturally has caused some delay in those interviews commencing, Judge. Just this morning, the prosecutor's office did receive from the sheriff's office a flash drive with over 340 items. That includes in-car video. It includes recorded witness interviews, witness statements, all things that we will turn over to defense. But as this court indicated, discovery is ongoing and the reports are continuing to come in. So this is, by the nature of the case and the scope of the investigation, this is going to take a little bit of time, Judge.
Thank you. So with that, Ms. Lofton, I'm assuming you're requesting an adjourned probable cause conference date, or both parties are, I would assume.
That is correct, Your Honor. I want to make sure that we are able to view all of the discovery before we make an informed decision about whether or not we will be holding the preliminary examination. So I am asking that already scheduled date be adjourned until after the new year.
Thank you. And if we do schedule it on January 7th at 9 in the morning, will that give you and Ms. Hopp enough time to properly make that decision?
I believe so. Your Honor. If for some reason there is an even longer delay in receiving the discovery, Mr. Keast and I can contact the court.
Certainly.
That sounds good. Have you discussed with your client the waiver of the statutory time period?
Have, Your Honor. My client understands that he has a right to have a preliminary examination within 21 days. Because of the extreme volume of discovery, my client is fine with having the exam set outside of that 21-day period, so we can all be on the same page and so that he can review all of the discovery in this case.
Thank you. Mr. Crumley, did you hear and understand what your attorney just stated?
Yes, ma'am.
And are you in agreement with that?
Yes.
So you're not waiving, of course, your right to a preliminary exam, just the right to have it heard within the statutory time period. And that is, of course, so your attorney can properly prepare for a preliminary exam if one is necessary. Again, do you understand and agree to that?
Yes, ma'am.
I do find good cause to waive that statutory time period. I will adjourn the probable cause conference to January 7th at 9 a.m. And I guess I would ask if this should be done remotely or not, just like today. Does that make sense under the circumstances?
Your Honor, at this point, we can set it for a remote hearing. If in between now and that date, Mr. Keast and I decide it would be better to be in person based on what will be actually taking place on that day, we can definitely advise the court.
Absolutely, because of course, either of you can make that request, and if either the prosecution or defense would require that, then it will be in person. So we'll initially set it remote and we'll go from there.
That's fine. Thank you, Jim.
Thank you. Ms. McKelvey, do you have you had a chance to meet with Mr. Crumley? Were there anything that you wanted to indicate?
Your Honor, I did have an opportunity to meet with him on Friday afternoon. At this point, we're able to interact, through the normal process on the screen. Your Honor, I don't know whether this is the appropriate time or you would prefer a motion. I do have concerns that his confinement at the Oakland County Jail and pursuant to MCL 764.27A, I'm not sure that he is fully away from the sounds of the adult inmates. And pursuant to the court rule, basically 6.909, there really has to be an assessment that he is either considered a menace to other juveniles or may not otherwise be safely detained in a juvenile facility. I understand the severity of what occurred. I think everybody does, including Mr. Crumley, but I don't know that simply, indicating that because the victims were of his age, that he would necessarily be a menace. So I do have concerns for him and his mental and emotional well-being. He currently is not able to benefit fully by what every other inmate at the jail can. Some has been due to a watch, but it is just very difficult. And the court knows the jail isn't conducive. It's not designed for juveniles. So, so I would just like some direction. Do you want a written motion and I can lay everything out? I just feel that if I have to look out for what is best interest, it's not being at the jail. I believe his needs can be met at the village. At least he will have greater human contact. He will have more services available to him to help him through this. I just feel that it is truly in his best interest, and I don't know that he really meets the standard of the court rule and the statute. And I know that his charge is not unique in the sense that there have been other children housed at the village with these type of offenses and being charged as an adult. I just feel that I'm not being humorous when I say this, but he could still at least be in school. I mean, there are things, he is still 15 years of age. And there are certain things, many things he's not going to get at the jail. And so I'm imploring you on behalf of him and what's in his best interest that we allow him to go back to the village. I'm not aware for the brief time that he was there, he caused any difficulty. I just think for his age, his mental, physical, emotional well-being, housing him at the village would serve him more than where he currently is. I know from what he told me on Friday, he hears adults in the cells next door to him. Pursuant to the statute, he's not supposed to, and I'm of the belief that they are adults, that they are not other juveniles.
And Your Honor, I can speak to that as well if before Mr. Keast has an opportunity to respond, Your Honor. I
Sure.
watch the arraignment, and I understand that Mr. Keast made the argument at that time pursuant to MCR 6.909. And after reviewing that statute, Your Honor, I honestly do not believe that my client should be considered a menace to other juveniles. This is someone who has never been in trouble before. This is not someone who has a history of assaulting kids his age or any other negative contact with his peers. This one isolated incident is all that we're looking at here today. And also, I'd like to speak to the fact that there are other juveniles housed at Children's Village charged with murder. This would not be the first time. There's others there now. So I definitely believe that society is protected, as well as the other juveniles at Children's Village, if he was to be returned to Children's Village. And again, I also spoke with my client and agree with Ms. McKelvey. He's being housed in the clinic. The clinic is still being used for adults that have medical ailments and medical issues. So there are adult inmates that are housed around him. And if you look at the specific language of the statute, I believe that we are violating that statute.
Thank you. Mr. Keast?
Thank you, Judge. Judge, this cannot be compared to any other case that this court or any court in this county has seen before. And calling this an isolated incident, quite frankly, does not do it justice. This was a mass murder at a school, Judge. This was planned. It was premeditated. The evidence that we have and that we discussed at the arraignment showed it was premeditated for a period of time before it was commenced. The defendant didn't just attack other individuals. He targeted juveniles. This defendant fits MCR 6.909 to the T. This court has already made a ruling that the presumption is great that the juvenile committed the offense and the juvenile's charged with first-degree murder. This court already made the ruling that this court could move the defendant from the Children's Village to the Oakland County Jail. I've spoken with Captain Thomas Vita of the Oakland County Jail. He has provided me with watch sheets. This defendant is monitored every 15 minutes. His food intake is monitored. His weight is monitored. He has access to mental health care should he choose. He has access to medical care should he choose. If counsel is prepared to put such facts on the record regarding the Oakland County Jail's inability to house this defendant, I would ask for a written motion. And I would also ask this court to review in camera the Oxford High School video that does in fact prove beyond any doubt that this defendant is the individual who perpetrated this offense on other children, Judge. Children's Village is not a secure facility. They have had escapes in the past, in the recent past. I can't imagine a situation where we could put this defendant in a school environment after what he did on November the 30th, Judge. So if we are going to readdress this ruling from this honorable court, I would ask it be by written motion. I would ask the opportunity for this court to review certain items in camera. Thank you.
Thank you. The court rule that is being addressed is MCR 6.909, which is the place of confinement for the juveniles, and allows the court for a juvenile confined in a jail or similar facility designed and used to incarcerate adult prisoners upon a showing that the juvenile's habits or conduct are considered a menace to other juveniles. While I did make a ruling prior, I still feel strongly about that his conduct could be a menace to other juveniles. I think his placement is appropriate in the adult facility, specifically the Oakland County Jail. And he, of course, shall be confined and meet the statutory guidelines when a juvenile is in that facility. So the only thing I'm hearing right now that may potentially be a violation is that he can hear other inmates who are adults. Is that correct, Ms. McKelvey?
Yes, Your Honor, that's my understanding.
Okay.
Judge, I will speak. I'm sorry, I did not mean to interrupt, Judge. I will speak personally with administration at the Oakland County Jail as soon as we end this call, and I will make sure that the defendant is neither within sight nor sound of any adult at the jail.
Thank you. Obviously, we need to be compliant with the statutes, and if that is it is obviously a concern, and thank you for addressing that.
Thank you.
Anything further?
No, Judge, I will
Thank
speak
you.
with counsel, and we'll make sure that discovery gets to counsel as soon as it is available.
Nothing further from the defense, Your Honor.
Thank you. You may all disconnect. We'll see you back.
Thank
in
you, Your
December.
Honor.
Thank you, Judge.